Good morning. Sorry, we had a little bit of a technical difficulty. We're a little late and it takes a little while to get people to come on. So we're going to wait a couple of minutes while people are joining, and then we'll get started. Thanks for your patience. Okay, we're going to get started. Good morning. My name is Jill Thompson. I'm the AVP of underwriting here at Optimum. Thank you everyone for joining us. I do want to mention some upcoming virtual seminars and webinars. Jean-Marc Fix will be doing something on COVID in September. Underwriting will have their virtual seminar in October, on October the 12th. It'll be a half day in the afternoon. Monica Klink will be speaking at the Reinsurance Roundtable at ICA conference on October 2nd. Our in-person underwriting seminar will be next March. And then also we will have our first ever claims seminar next October in October 2024. Remember, if you have any questions, please put them in the webinar Q&A chat options. I think we're going to stop in the round 6 and ask questions. And then also at the end, we'll do a little bit. And otherwise, if we don't get to all the questions, we'll have you guys send us the questions at info@optimumre.com, and I'll put it in the chat so that way you guys have it. Let's see. There will be a survey after the seminar. Please fill that out. It helps us tremendously find new topics for you, and then also improve this stuff that we've already started. Let me go ahead and introduce Michelle. Michelle is currently the claims department manager. She started at Optimum 11 years ago and as an intermediate claims analyst. Before that, she worked as a claims examiner at a direct company for 4 years. She really enjoys the investigative part of claims. The more complex, the better she likes them, which doesn't surprise you that she loves the true crime stories and movies. She was born and raised in Las Vegas, Nevada. And then she can share a big secret on how to win at the casino. Don't gamble. She said the odds are not good. But she says shopping purses and shoes, you'll win every time. And then go ahead, Michelle.
Sorry, yeah, technical difficulties continue today. Excuse me. And thank you for joining me today this morning to talk about accidental death claims. These are my absolute favorite types of claims, because when I am reviewing an accidental death claim, I literally have 2 boxers or maybe 2 lawyers in my head going, payable, don't pay, payable, don't pay. And I fight with myself. I argue my points on these cases routinely. So today we're going to go through some of the first steps, we'll call them rounds, that you have to go through in getting yourself ready to review these claims and make the most reasonable and fair decision. And we want to be fair both to the client and to our company. We want to protect both the client's rights to get paid and the company's rights to not pay a not payable claim, of course. So I am from Las Vegas, but my background today shows Las Vegas because we all know Las Vegas is a boxing capital of the world, among with a few other great cities, but it's always fun to be at a boxing match in Las Vegas. So we're going to be in Las Vegas today. All right. So we're going to do the crash of the Titans. Okay. We're going to take 12 rounds to knock out some accidental death claims. Okay. So the first thing that we have to do, first things that boxers have to do, these two boxers in my head, is we've got to prepare for the match. And as we're preparing for the match, the first question we want to ask ourselves when we get that accidental death claim file in front of us is, do I have everything that I need to investigate the claim? Practice makes perfect. The more ADB claims you review, the more familiar you'll be with what you need. And many of the documents that could be useful to you in your investigation will always depend on the type of accident that you're investigating.
Let's get ready to rumble!
All right, so that, I don't, were you guys able to hear that? I hope so. That is my favorite guy. That gets us all pumped up and ready to go when we're getting ready to go through these boxing matches. So let's get started. Okay, so round one. I couldn't get the bell, so I'm going to make the bell noise myself. Ding, ding, we're in round one. All right, round one. What do I need first? I need the policy form. And along with that policy form, there should be included that accidental death benefit rider. That rider is very important to us. The rider gives us first the policy's definition of an accident. It also tells us the terms under which the accidental death will be paid. There are many terms, and they vary from policy to policy, and it tells you exactly when, where, and how to pay that claim. That is what I mean by terms. Also, it gives us the exclusions that would apply. I have yet to see an accidental death benefit rider that didn't have some type of exclusion to an accidental death. And we'll go through those. Okay, ding, ding, we're in round two. So we have the policy, we have the rider, we're able to see the terms of the accidental death benefit rider, the definition of an accident per that rider, and also the exclusions that apply to that rider. So in general, the definition of an accident, according to Merriam-Webster.com or dictionary.com, is an unforeseen and unplanned event or circumstance, an unfortunate event resulting especially from carelessness or ignorance, or an unexpected and medically important bodily event, especially when injurious. That number 3 definition is basically what we deal with, but all 3 of these definitions we could take and combine and create a policy's definition of an accident. And that's what we see most of the time, is some combination of these 3 general definitions. Say ding, ding, round 3. Okay, samples of definitions of an accident. And I just took 2 that I see kind of most often and put them together. It's a death which results in from an accidental bodily injury sustained as the direct result of an accident. And it's independent of all other causes. That becomes very important, that it's independent. The accident has to be the direct cause of the insured's death. There may be a few steps in between there, but we should be able to go right back, like 1, 2, 3, right back. Accident occurred, and then 2, 3, 4, 5, 6, death occurred. And there should be no interruption in there by anything, especially an exclusion to the policy. Okay. Oops, I'm sorry. Also, another way they define it in the policy is that the death resulted independently of all other causes. Okay, so that means, and you'll see this when we talk about the exclusions, you'll see this, that nothing else happened that caused this death. There was no outside circumstance that caused a death. That's very important when we're looking at the documentation that we receive, to look to see, is there anything else that played a part in this accident, before the accident or during the accident, that would cause the accident not to be the only cause of the insured's death. And ding, ding, we're in round 4. Other common terms found in the definition of an accident. The policy will define a time frame between the time of the accident and the time of the insured's death. Usually we have a 30, 60, 90, or 100-day period from the time of the accident to the insured's death, and the insured's death has to occur within that time for us to say that it was an accidental death and possibly eligible for this extra benefit on the policy. The death of the insured and the accident must occur while the policy is in force. It seems like a simple matter, but both of those events must occur while the policy is in force. It could be that the person suffered an accident and 60 days later died, and between the accident and the death, sometime during that, the insured applied for and was approved for policies. We have to be careful of this type of thing when we're looking at simplified issue policies, jet issue policies, things like that. And also, the death of the insured must occur before the insured's, I put '50th, so whatever age that the policy determines is, when you're eligible for this accidental death benefit, say it's 70, 75, 65, those are common ages. If the insured on the date of the accident had reached that age as defined by the policy, then the insured would not be eligible for this accidental death benefit. So before I even get into the nitty-gritty of the death benefit, I'm going through my rounds and I'm reading this accidental death benefit and comparing the information with what I have to make sure that none of these things apply. Okay, ding, ding, in round 5, other helpful information that will help us, if we have this in our packet, these things will help us to know whether or not we can continue on. We have enough to investigate this accidental death. First things first, we always need a death certificate. Now, with the death certificate, we want to be careful that we don't just take what's on the death certificate, the manner of death listed as an accident, as the end all to be all. That is the ultimate conclusion that this person died of an accident. It is helpful information. However, as claims analysts and possibly underwriters who look at claims, we all know that death certificate, the manner of death, can be changed upon further investigation. And sometimes we have a small funeral home director that's filling out the death certificate, and he may not have done a full investigation to make sure that this was actually an accident, not a suicide or perhaps a homicide. So don't take the death certificate at face value that this is the end all to be all. This is what caused the accidental death. Okay, we also want to look at statements from the beneficiary. When you're doing an accidental death claim, it's very important to get a claimant statement from the beneficiary. I've said it before in past webinars, and I'd like to repeat it again. It is very important that we get a statement from the claimant. The claimant knows usually what took place, and sometimes claimants accidentally just tell on themselves. We may think that this person died in an accidental ATV accident, and the claimant will write something on that claimant statement that will tell you that maybe the ATV was tampered with or something like that. And so we want to be careful to look out for things like that. Claimants don't always say those things that they'll say to the insurance company on a police report. A lot of people, it's well known, they don't like to talk to the police, so they don't tell the police everything. So the police report is supposed to be an impartial, just the facts, ma'am statement, and that's great. So we use a police report to tell us what took place. We also want to make sure that included in that police report, along with all the little boxes that we see filled in, that we also get a summary from the investigating officer. We want to know, what did that investigating officer think about as he was think of the circumstances as he was filling out that police report. That's very valuable information. Also, will provide some information that's not just factual, maybe more of an opinion, but may be able to lead us to a proper conclusion or make us question something and gather more facts. Other first responder reports would be the fire and rescue reports. If the person died in a fire, we want to know, was that fire an arson? Because that may change it from an accidental death to a homicide. Not all accidental death benefit policies cover homicide, so we would need to know that. And the ambulance report, if the person was still alive after the accident and in the ambulance, the insured may have been making statements as to the circumstances that surrounded the accident. And some of those statements may have bearing on your claim. So be careful to look for those things. If you have information that the insured left the scene of the accident in an ambulance and they were still alive, definitely want to see and look into requesting that ambulance report to see what was going on while the person was in the ambulance. Were they conscious? Were they talking? Were they making, statements about the circumstances, statements about the people who were there with them, that maybe you could go back to and interview those people to see what was going on. Eyewitness statements. Were there people in the neighborhood or, in the house or wherever, in the building, wherever this person happened to see what was going on? Is that information included in some of your first responders reports? Or is it the name there, and maybe perhaps you could reach out if it's simple enough to see, just to gather some facts. Sometimes things are hearsay and you can't use it, but you have to consult with your legal department as always. But getting eyewitness statements is a good idea if you can on these accidental reports. Another thing is medical records. If the insured survived the accident, especially for a number of days, and was admitted to a facility, you'll definitely want to get medical records. The doctors are going to ask, how did this happen to you? What happened? What were you doing? Who was there? Things like that. The doctors will be a second source, like the police, to give you some facts surrounding, because the doctors need to know because they want to treat. Medical records are extremely helpful when it comes to accidental overdoses. So they can let you know the insured state of mind. Were they suicidal? Were they not suicidal? Was it because that makes a difference. If you were suicidal and had suicidal ideations and you had an overdose, were you trying to commit suicide? That could show intent of trying to commit suicide, versus they were just trying to, feel good and accidentally took too much of a drug. Also will tell you the difference. Also can let you know whether or not this person was taking street drugs, which could apply to an exclusion, versus were they taking a prescription? Did the prescription belong to them? Were they taking the prescription as prescribed? Doctors find out that information for you. Very helpful to look at the medical records. Another thing that we do here at Optimum Re, and we often see our clients do, is we will go on the internet or wherever we can find some news articles about what happened. One reason we do this is because as a part of our Slayer investigation, and Slayer is whether or not the beneficiary was involved in the death of the insured, we want to see, who do the police suspect? Not always is that information included in the police report. Sometimes they just leave it out. They don't say anything about it, but a news report will tell you, oh, it was a drive-by shooting of an unknown assailant, or perhaps it was the insured spouse that was at home with them when this person drowned, or something like that. So you always want to look into the news articles, always just a second source of information. Social media posts, friends and family of the insured tend to know more than Joe Q public about what took place. And they'll post it on their social media. Again, you want to consult with your legal department to see if any of this information is admissible, something that you could use if in determining whether or not you have liability on the accidental death benefit claim. But it's also just very useful information into the state of mind of the insured, into the circumstances surrounding the death of the insured. Friends and family tend to know more than anybody else does about what's going on. Okay. So, and this is just a by the way, if the claim happens to be contestable on a lot of applications, not all, but on a lot of applications, we ask questions about avocation and occupational or sports that are dangerous, like skydiving. Do you fly a small crop duster plane, like my yellow friend here, Bumblebee? Do we fly a plane like that? Is this person, a mountain climber, or I forgot what they call it, where you jump out of the helicopter onto the top of a mountain? Is that something that is a part of this person's life? And was it disclosed on the application? If you find that it wasn't, and in the information from the other documents you gathered, you find that this person does do this and on a regular basis, you may be able to have an implication of material misrep to rescind the policy because the person didn't tell you of a hazardous sport or occupation or avocation that they participate in on a regular basis. So keep that in mind as well. Okay, ding, ding, we're in round 6, so I'm gonna stop here and ask, I see there's one question and one chat.
What if the policy is on extended term?
Okay, so if the policy is on extended term, what extended term does is it keeps the base policy in force and uses the cash value, but it doesn't pay for all the riders. So an accidental death benefit is normally a rider, and the extended term insurance is only paying for the base policy. So usually the accidental death benefit would not be payable. Any other questions?
Any more questions for round 6?
Okay, we will proceed. Okay, I got to the common policy exclusions, and my copy paste kind of just petered out on me. So excuse me, again, I'm having some technical difficulties, but we can go over these. So for common accidental death benefit exclusions, we see that if the insured was participating in a felony, the accidental death benefit would not be payable. If the insured intentionally harmed themselves or was trying to commit suicide, that is a very common exclusion. Uncommon exclusion, but definitely out there, is homicide. There is a big argument amongst claims analysts and examiners that I've heard quite often whether or not a homicide, because it's homicide is usually some type of an intentional act, could be defined as an accident. And the argument is whether or not it's an accident on part of the insured, because most people don't intend to get killed, or is it not an intentional act? Is it an accident, on the part of the insured? Is it seen as an accident, which is the most common viewpoint of it, that homicides are covered. Also, accidents where the insured is under the influence of either alcohol, some type of poisonous, have inhaled some type of poison gas, under the influence of street drugs or prescription drugs, not prescribed to them or not taken as prescribed to them. Those are common exclusions to the policy, and I do apologize for my copy paste that did not happen here. Okay. So
Michelle, I did let everybody know that when we send the original presentation at the end, these will be in there for their reference.
Thank you very much, because I did have some real technical difficulties with my copy paste this morning. I don't know why it didn't want to go back and forth, and I have that feeling my VPN had something to do with it, but okay. So we're going to go into our first case study. Okay, so in this case study, Clyde has an accidental death rider policy with ABBC Life Insurance Company. Clyde is a known drug dealer and was shot to death at a convenience store. The police report notes that Clyde was leaning in the driver's side window of the door of a white car when he was shot and killed. The assailant is unknown. Clyde is a known drug dealer in that area at that convenience store. There are two witness statements. One witness says that Clyde's arms were folded across the window of the car like this. And the other witness statement says that Clyde's hands were in the car like this. So I just want to poll, given everything else, nothing else, no other exclusions apply. Now, it looks like, there's no homicide exclusion to this. I just want to poll the audience with this information, not contestable, not anything like that. Do you think that this accidental death benefit would be payable or not payable? Yeah, I'll give you a couple minutes to answer. Almost there. All right. So I'm gonna, oh, no, we're still going, sorry. Okay. I'm guessing everybody has gotten to answer. Oh, we're still going. Sorry. I'll give it one more minute for everybody who wants to answer to answer.
You want to go ahead and end it?
Yeah, I'm still got, every time I go to end the poll, I get a couple more answers, but I think we've got a good. I'm gonna go ahead and end the poll and I will share the results with you. So 39% of you say that the claim is payable. More than quite a bit more than half, 61% say the claim is not payable. Now, I'd be interested to hear about the ones who say that it's not payable. If we have a quick 1 minute to just throw some answers out there. Those that say it's payable, why? Those that say it's not payable, why?
Do you want it in the chat or do you want it in the question?
In the chat is fine. Either one, which is easier for you, Jill?
Either one is okay. Just yeah.
Just real quick, and I'm going to give you 1 minute. Okay, raised hands. If you could put it in either your chat or the Q&A, because we can't respond to the raised hands. Getting anything, Jill?
Yeah. Okay. So moral hazard, eyewitness testimony is unavailable. Payable, I don't see where there is an exclusion. Not payable because he approached the engaged in a situation. The police report didn't say he was committing a crime, hence it's payable. Payable is the client wasn't actively participating. Needs more investigation to see if doing a felony. I
Okay.
mean, there's lots of different opinions.
Okay, yes, there was lots of different opinions at Optimum Re on this claim. This claim we did go ahead and recommend to pay. And the reason was because we could not prove what Clyde was doing. Just because Clyde was a known drug dealer doesn't mean that at that time, at that particular time, that Clyde was selling drugs. Looked like Clyde was selling drugs, smelled like Clyde was probably selling drugs, but we had absolutely no proof. We had one witness that said his hands were like this, so he didn't seem to be handing anything over to the assailant. By the way, the assailant was the driver of the car. And we have one witness that says his hands was in there. Very well could have been handing something, but we had two conflicting eyewitness statements. Nothing cleared up by the police. No further investigation by the police. As far as they were concerned, the unknown assailant in the white vehicle shot Clyde for unknown reasons. And so tie goes to the runner. Yes, it looked dirty, but we had absolutely no proof. We could not prove it. The burden of proof on ADB claims, and this is important, the burden of proof on ADB claims, because we're paying an extra benefit, is really on the beneficiary. But if we can't prove it's not payable, tie goes to the runner. As we like to say at Optimum Re, tie goes to the runner, and we go ahead and pay. We don't want to end up in litigation because we tried to assert a fact that we couldn't prove, I'm sorry. So we went ahead and recommended to pay this.
So what if they I'm sorry to interrupt. So what if they decided that they convicted the driver, and he's like, he wasn't giving me my drugs or whatever. So then could you have paid it? He must not have said anything, of course. If
the assailant was never caught in this particular case, they never did find him. They just said it was a male assailant driving a white car, which also made it really easy when we were looking at the beneficiary. The beneficiary was his mother. So we know the mother wasn't the male assailant. If the mother hired somebody, whole different case scenario, but
there wasn't
none of that was indicated, right? So we have no information that Clyde was committing a felony. That's the end. Clyde didn't have any drugs in his system. No other exclusions applied. So we had to go ahead and pay because we had no proof of what Clyde was doing. We don't know. He could have been leaning over and just having a conversation with a friend, My colleague and I argued this claim for 2 days. My colleague said it is not payable, and I kept telling me, tell me what you can prove. And it was a great discussion between my colleague and myself. So wanted to share that with you. We just could not say, every claims analyst takes themselves to court and we sit in that deposition chair, or we sit in the witness stand and we sit in front of a lawyer, those two lawyers that are going through that boxing match in my head, and said, what can you prove? We couldn't prove anything other than he was leaning in, having a conversation, and he was shot. Maybe he said something offensive. We don't know. Any other questions? Yeah. Okay. All right. So now, again, looking at my presentation, I'm just going to present some more case studies that I have written down here because I'm looking at my presentation and I have about 3 that did not copy and paste, and I don't want to go through this. So we were on round 7, right? Yeah.
Yes.
Okay. So we're going to go through and I'm going to use these ones on here. I will get these copied and pasted onto my presentation for you. I apologize for this technical difficulty, but I had some issues with my VPN going in and out, and it did not want to copy and paste from Citrix. Anyway, so my next case is we had an elderly lady, okay, and this particular policy, termination age for the accidental death benefit is age 100. We had an elderly lady who had congestive heart failure, cardiac artery disease. She had a history of stroke, a history of TIAs, And she had had several witnessed falls where she got syncope or just got a little dizzy and she would just fall. And none of those falls resulted in her death. Right before her death, she had a unwitnessed fall where she fell, hit her head, and died of a subdural hematoma. She was, there's 6 days lapsed from the time that the lady fell and hit her head, and she was in the hospital. The hospital records only focused on her treatment for the subdural hematoma. Of course, they talked to the family. None of the family disclosed, the family did talk about her history of falls with the stroke and the syncope that she had experienced. And because she was an older lady, she didn't really have any conditions we wouldn't expect a person of her age. I believe she was age 80. So this, now she died of the subdural hematoma. We're looking at the medical records. There was no police report taken. There was an ambulance report. The lady was unconscious when she got into the ambulance, so she was not speaking. She was unconscious when she got to the hospital and shortly thereafter intubated, so not speaking. And she never woke up or was, the intubation tube was never taken out. So she was never able to really speak. All of the history for this lady came either from prior medical records at this facility or from the family at the time. So we get the death claim. The death certificate says manner of death is accident due to a fall, and secondary, the primary cause was subdural hematoma, the secondary and acute hypoxic injury, and the secondary was to the secondary cause was to a fall at home. Okay, so
And just FYI, guys, there isn't another case. The Michelle's presentation was she was having issues, so this case study doesn't have its own page. And then also, was this case contestable, Michelle?
No, this case is not contestable. None of these cases that I'm talking about, I have a few more, none of them are contestable, and none of them, all of my slides are blank that I copied and pasted on. I apologize.
Talk about technical difficulties right before your presentation.
I mean,
Good way to pivot, Michelle. All right.
Beautiful last night, and I'm so glad I wrote these down because I was doing my copy and pasting this morning and I was trying my best to get the sound on, and I was like, oh, I'm going to copy paste, and nothing happened, and my VPN turned itself off. So here I am, and I am so sorry. I'm just like mortified, but I'm going to keep going.
Now, do we have a poll for this one?
Yeah, I'm wanting to poll on this one. These are the facts that I have written here.
And so she's a lady, she was in her 80s, she had falls, but it wasn't contestable. She has a history of cardiovascular and cerebral vascular disease. But nobody saw her
falls, none of which she died from. She did have a history of syncope, where she was fainting and falling. She also had a history of just being unsteady on her feet and fall. All of those falls were witnessed. This particular fall that resulted in the subdural hematoma was unwitnessed. She was at home by herself in the kitchen. Okay.
Yeah, so nobody saw her fall.
Nobody saw it.
Now, did the prescription, the medical records give you any evidence that the client was not taking her medications as prescribed?
No, no indications. The medical records centered solely around the accident. What happened? They were talking to the family about the accident. They centered solely around that. Not even really, they gave a past medical history when they do the history and physical that was given by the insured's daughter, but no, and the medications were what we would expect to see from somebody who had suffered strokes and had cardiovascular disease and cardiac artery disease. They were all, nothing that we would expect, no narcotics. Think the most powerful pain medication she was on was maybe some meloxicam for a knee issue.
Gotcha.
Nothing
And
there.
the death certificate specifically said it was a hematoma from a fall.
Subdural hematoma, manner of death, accident, and then the secondary cause was fall at home. Yeah.
Is there an age limitation on that rider?
This lady was 80 years
Oh,
old.
you said it went to 100, right? At the
It
beginning?
went to 100, yes.
Okay.
And this lady was 80 years old. Okay. So it looks like everybody has stopped. I'm going to go ahead and share the poll. So 72% of you say that this claim is payable and 28% says not payable. We did go ahead and recommend to pay this claim. Again, we were just missing evidence of any type of exclusion that would apply. The lady, toxicology on the lady was clear, no illegal or even prescription drugs that we might expect to see like oxycodone or anything like that. No fentanyl, nothing like that for her pain. She was taking, blood thinners and her blood pressure medication and all of that. What did hold us up for just a bit was the syncope. She had a well-documented history of syncope. So we were like, well, did she faint and fall? And again, this is something that my colleagues and I were talking about. Well, she had a history of fainting. She could have fainted and fell. And the key word there was could have. Did she faint and fall? Or did she trip over a rug in her kitchen, hit her head on the cabinet, and pass away 6 days later? We don't know. She wasn't available. She wasn't conscious to say what caused it. So again, tie goes to the runner, you pay. Okay. Any questions, comments on that one?
Nope, I think we pretty much gave everything that everybody had.
Okay.
We try to kind of repeat some of the things for the case, the other cases
And I will get
going
these.
forward.
I wish I could share my Word document with you where I have them all copied and pasted, but I can't. Because that was my next trick to do. Okay, so the next case I have for an ADB claim was I have a lady who was in a car accident. It was a single car accident. The lady was driving on a, let's say, a country road, 2-lane road. It was described as country road number CR This lady made a turn, a sharp turn, and didn't navigate the turn well, ended up going into a ditch. The car popped up, and popped up is a quote from the police report, popped up and hit a tree that was on the embankment of the ditch. The young lady passed away. When they did the initial police report, there was no smell of alcohol. So they took her in, no autopsy was performed. This is unusual, and this is problematic for claims people because we want to see that autopsy. We want to see, but they did do a toxicology report on her blood before her body was released. In her blood, she did have some prescription drugs along the form of fentanyl and I believe oxycodone. Okay, so medical records were requested. This young lady did have back pain, arthritis, and it was unusual for her age to be seeing these type of things, but she had back pain from a prior MVA, arthritis, and she had a history, and that's all it said, a history of drinking. The toxicology only revealed the oxycodone and the fentanyl. The exception, the the rider, the exclusion to the rider said driving under the influence of alcohol or taking prescription medicines not prescribed to you or not as prescribed. And this was the end of the facts that we got on this case. No
Okay.
medical records were available from the hospital because she was dead upon arrival.
All right. So it was a female motor vehicle accident. She was the only one involved.
Age
She was
32.
driving on a country road. She took a sharp turn and went through a ditch and popped up or hit a tree. And
Popped up was the word, popped up on the embankment.
so they didn't smell any alcohol. They didn't do an autopsy. They did a toxicology. They originally thought it might have been alcohol related, but the only thing they found was fentanyl, oxycodone, and she does have a history of back pain, arthritis, that sort of thing.
Right. And also noted was a history of
Drinking.
drinking. Did have a history of alcohol. That was the word. History of alcohol. I'm not sure what that means.
Yeah. Well, from reading records of myself, it could be their way of saying more alcohol than should be, but yeah, they like to not be very specific a lot of times in those APSs.
Correct. Okay.
And then just while everybody's answering this, on the last one, somebody had a question, I missed it, I'm sorry. It was, where was it? Would the fainting result in not being, why would fainting result in it not be accidental?
We looked at the syncope because we were worried that she had fainted and fell and hit her head.
But you didn't, nobody was around or nobody saw it, so you can't prove. Just because they had it in the past, they don't know that you really had it that time, or you didn't just trip on something, the dog or the carpet or whatever.
Correct. And our client was really concerned about that history because it was well documented that she had a long history of syncope, probably due to the strokes that she was having or TIAs.
And those oxycodone and fentanyl, they were all prescribed. I mean, they felt that she was not ODing from there. She wasn't taking more than what she was supposed to.
So when we found the oxycodone and fentanyl, and this was all that we had, we wrote to the doctor that the beneficiary, well, not we, I'm sorry, our client wrote to the doctor that was on the claimant statement, the doctor that she saw. They wrote to the doctor and asked, was she prescribed these medications and why? And they wrote to the doctor who was, I believe he specialized in pain medicine. And he did say that he was prescribing those for her back pain and arthritis. And it was very unusual to see arthritis for a young person. So we were kind of questioning that as well. Does she really have arthritis? It's pretty young for arthritis to start to, definitely not unheard of, but a little unusual at 32 years old. So we wrote, he was prescribing those medications. Those medications were in her system, according to the toxicology report, at a lethal level.
At a lethal level. So you can't prove whether or not it was accidental overdose, or she accidentally took too much, or she just took it on.
Or was the doctor prescribing too much? So again, these are my tie goes to the runner. I give these cases because, and I really look at these cases because they cause you all kinds of thought process. They cause those two boxers or two lawyers in your head to immediately start arguing. And if there's a claims analyst out there who doesn't know what I'm talking about, or who could back up what I'm talking about this little conversation that goes off in your head between these two boxers or these two lawyers, well, she was taking these medications and she was driving. She shouldn't have been driving. The doctors say don't drive. Well, was she taking them as prescribed? How long has she been taking them? Did she have enough tolerance to drive? All of those kind of things have to be, thought about. And again, here, tie goes to the runner. They were in a lethal amount. Did she have enough tolerance for that? That was the lawyer that was going off in my head. Yeah, well, it was lethal for you, lethal for I. Is it lethal for her? She had been taking them for years.
And you said that there wasn't any alcohol, or they
No
didn't show any alcohol on the toxicology.
No alcohol. No, nothing else on it. She didn't even have caffeine.
So to confirm, the alcohol was an exclusion of the contract, but not elevated levels?
Correct. So alcohol, the exclusion was driving under the influence of alcohol or taking street drugs or prescription medication not prescribed to you or not as prescribed to you.
So you couldn't prove how much, if she was taking it not as prescribed.
Right. We want to make an assumption that because they were lethal levels to, and I believe when they make up those reports about what's lethal to a person, they're talking about average person, right? Not person who has been on these medications for 5-10 years, and has some type of, we all know these medications, a human being will develop tolerance. So we don't know if she was taking them as prescribed. We do know they were prescribed to her. So again, tie goes to the runner. These are very difficult claims to, come to a good conclusion about. And then we also have that standard that because we're paying an extra benefit, the beneficiary really should be proving to you it is payable versus you proving it's not payable. However, no one wants to get into court and argue with the beneficiary. The little old beneficiary, trying to prove that my daughter or my sister had a tolerance because she had been taking these medications for so long. She had been driving, and never had a problem with these medications versus the big bad insurance company say, yeah, we'll prove it. Okay.
Okay, you want to end the poll?
And I'm going to share.
Oh.
And I think my compadres agree with me that this is payable. How are you feeling about that, Jill? This is becoming a conversation between me and you, and I think I like it.
Well, it's a different, first of all, that's kind of the underwriter's job in the beginning to locate that alcohol problems, the fentanyl problems, the pain problems. And if we don't, then it's your problem.
Correct. That's absolutely right. Okay. All right. Well, I have one more accidental death claim. Excuse me here. Let me get to it. And this one was very interesting. This gentleman, and for this one, this young gentleman was in his apartment complex, or in his, I don't think it was an apartment complex. I'm sorry. He was in a neighborhood and he was standing outside with a bunch of his friends and he was shot. And there were so many people outside. I want to say more than 20 or 30 people outside. And by the way, this one made it onto the first 48.
It made it on what?
The first 48, this case here we have. They were standing outside, 20 or 30 kids standing outside. I want to say they were celebrating something, but I'm not sure. That wasn't included in the information that we have. They were standing outside, shots were heard, and people just took off running. The insured was found face down in between two houses in a yard. There was no fence in between the houses. He's found face down, shot in the back. Okay, clearly a homicide. Well, we thought it looks like a homicide. The police report wrote it up as a homicide. And there was known drug dealing going on, according to witness statements. There was known drug dealing going on at this gathering of young people. The insured was a known drug dealer and was seen by witnesses to be selling marijuana at the gathering. None of the witnesses stated why the melee started. There's no cameras on any of the houses to give any indication of why the melee started. Also outside in this group of people was the beneficiary of the policy, the insured's mother. The the beneficiary of the policy was the insured's brother. The brother was a minor. The claim, if payable, would be paid under UTMA, which means the mother would have access to the proceeds. The mother was present outside when the melee started. It was unclear who did the shooting. There was 4 different type of bullets found during the investigation of the scene. All of the news reports, none of the news reports that we were able to locate, none of the news reports that the client was able to locate named any suspects in the murder. The client contacted the investigating officers, 2 of them, and asked if the mother or the brother, both of whom, I'm sorry, the brother was also present outside, if the mother or the brother were a part of the shooting. The police said they couldn't say. Standard exclusions apply. Homicide is not excluded. The insured did not have any, he had, I think, a minimal amount of marijuana in his system. And no other exclusions apply. No suicide. The police called it a homicide, just didn't know who did it. So for this case, do we see that this accidental death benefit is payable or not payable with the current information that we have?
Okay, so just to recap, so it was a young gentleman outside like a party celebration. He was in the neighborhood, lots of people. Shots were heard, fired, everybody starts running. He's found dead between 2 houses, shot in the back. The police says it's a homicide. There was no drugs involved. No, he is a drug dealer, but there wasn't any drugs being sold or people didn't report anything.
He was seen to be selling drugs at the
he was seen
he
to be
was
selling drugs while he was there.
Yeah.
But
there was no indication.
Benny was there, his little brother was there, who was the Benny. Because he's a minor, the mom would be the one that would control the money. She was there. You said she was pregnant. I don't know if that involves anything.
No, she wasn't pregnant. She was just present.
Oh, present. I thought you said she was pregnant. No wonder. I was like, I don't know how that involved.
No.
4 types of different bullets were found. There was really no suspects. Nobody said, who it was. The seating company tried to ask, the police, well, are the Benny and the mom suspects? And they're like, I don't know. And then he had a minimal amount of marijuana in the system. Is marijuana legal in that state?
Marijuana is not illegal in the state where this took place. But he was selling marijuana and he doesn't own a dispensary.
And he doesn't what?
He doesn't own a dispensary.
Oh, but he doesn't own a dispensary. Okay, gotcha.
Not legal for him to sell.
Okay, what do we got?
Let's quiz Jill.
Okay. You got a lot. It's really close right now. It's really close right now. as to what people are thinking. Let's see, got some more questions.
This is my last case, by the way.
Okay.
I saved the good one for last.
And then we have another question regarding that first case.
Okay.
Oh, people are filling that out. Isn't isn't 100 age 100 really old? I mean, wouldn't that be kind of risky?
Age 100 is very old. If I had my way in Michelle's world that doesn't exist except for in my home, I would not recommend accidental death benefits on a person over age 65. People get older. I mean, I'm younger than 65. And when I was a lot younger than 65, I fell a lot. I'm clumsy. You know what I mean? And I didn't have any health issues. I'm older now. My knees hurt a little bit and I'm still clumsy, and I'm not age 65 and I fall. When you get to age 65, so many things start happening. You know, your health, just normal things, your health, you know, starts to decline at 70, it gets a little bit worse, you know, mortality, right? So people fall, and falls, you know, at age 35, you can fall and survive. At age 75, you fall and break a hip. Not unusual for you to die from a broken hip. So yeah, in Michelle's world, I would recommend stopping the accidental death benefit coverage at age 65 or 70, but I am not a pricing person. I'm no actuary. I don't know how that works, you know, so, you know, they do have coverage. So
As the underwriter in this room, I think I concur. So there you go.
yeah, you know, but you know, people, you know, clients definitely have their reasons for doing it, you know, and providing
And
that
it could be
coverage.
an old one as well, an old
It's
policy
pretty
that they have.
new.
Oh,
You
well, see,
know, yeah,
there you go.
pretty standard. And it may have something to do when the policy itself terminates, if the writer doesn't terminate to the policy.
Gotcha.
We have
Okay.
whole life policies involved. That could be part of it. Like I said, I'm no pricing expert, definitely not an actuary who, you know, or a mortality expert who figures this kind of stuff out, you know.
Gotcha.
And I'm sure they price for it appropriately. But yeah, it just it's difficult on a claims analyst to look at a fall on an older. That's actually one of my least favorite claims to do, and that's when these boxers go a full 12 rounds, is on a fall on an older person who has medical conditions, and it an unwitnessed fall, or sometimes even a witness fall. I can, after this, we can talk about a witness fall, and we'll see what the audience thinks about this witness fall, and I'll let you know what we had to do on that claim.
Okay. I don't think we're going to get any more. This hasn't moved. So
I don't think so either. So I'm going to end the poll and share it with you. And we are right at half, which makes sense because that's right where we were, right in the middle. We have no idea who shot this gentleman. The two beneficiaries were sitting outside, and insurance companies are responsible for making sure that people do not profit off of crime, you know? So this policy, this claim right now is still pending further investigation. And the family on this particular claim isn't making very much noise.
So maybe they know something that
They know something.
So is it old enough to a sheet and give it to the state and say, you figure it out?
Not quite that old yet. It's 3 years old, usually a sheet, depending on the state. It could be 3 years or 5, you know, but this is definitely something that could be for an interpleader as well.
And I only know that because
really
Monica did a presentation on these a couple of days ago.
I'm sorry, I'll take that back. An interpleader won't work because we don't have competing beneficiaries. We are unsure of the information that we have. It's just sitting there. And
So
we don't
do you eventually just sheet it? You send it to the state or the court?
We recommend that the seating company try and gather more information. What I don't know in this particular case is the seating still following up with the investigating officer? Is the investigation going anywhere? Because if it's not, and the investigating officer can't prove that the mother or the brother had something to do with it, or that this particular insured was committing a felony, maybe he was selling drugs. There's no witness to that. They just said that he was selling drugs during this gathering. Didn't say he was doing it at the time. You know, he ran with the crowd. So nobody really knows what happened. To me, if this claim is going to go on much further, I would recommend to pay. We have no proof. And we can't let it go on forever, because the beneficiary, although not making any noise right now, could certainly make a lot of noise.
So how do you ever end it? Do I have the terminology right? Is it a sheet?
You could a sheet, but there's really no reason to a sheet. A sheeting you do when you don't have a beneficiary, when you can't locate a beneficiary.
Okay,
You know,
sorry, got the wrong words, Joy.
Yeah. Then you can't come, you know, when you can't locate a beneficiary, or the beneficiary isn't willing to, you know, send in papers or something like that. The beneficiary filed the claim. They're just not making any noise, which is unusual, but we don't want the beneficiary to start making noise. So my opinion on this claim, and this is just something that I was, you know, going through and looking at, and I was like, we probably need to go ahead and recommend to pay this claim. Because it's been, I think, 3 years and we haven't found any new information. But before we do that, we'll want to reach out to the investigating officers, or any investigating officers. We don't know if they're the same, you know, and see if there's any movement on this case.
Yeah, I mean, you would think that after 3 years, somebody would be upset that we even have a claim.
Right. That's a big red flag, is when your beneficiary is not fighting it, the payment. And it's a pretty good chunk.
Yeah, because I guess I was thinking you could do in a sheet is because you don't know if it's payable or not. So then you give to the state and have the state decide, but it's more about the beneficiary kind of thing.
More about locating a beneficiary.
Gotcha.
Whereas an interplea also seems like a good idea. Let the courts decide, you know, doesn't work because we don't have any beneficiaries competing for payment.
Okay, so a couple of questions. If he is selling drugs, you know, during it, wouldn't the felony exclusion apply?
If he was selling drugs at the time he was shot and we could prove it, yes, the felony definitely would apply.
And then it really wasn't just him that was shot. Was he the only one killed?
No, there was another person killed there, and they don't mention, all of that is redacted. You know,
Oh, because it's private, because it's not, it's
none of our
somebody
concern.
else's information.
Right. So all of that is redacted. He was committing a felony while he was there, but the exclusions say that the accidental death benefit is not payable if at the time of the insured's death he was in commission of a felony.
So he didn't have his hands in with drugs in it, handing it over to
No
somebody.
drugs in his pockets.
There you go. And then in a case like this, can you pay the base and then later decide on the ADV?
The base was paid because it was a non-contestable claim. Base was definitely paid. You can decide later on the ADV, but eventually you have to, we're at the point where we have to make a decision on this ADV.
Gotcha.
Any other questions?
Not
This
on
is
this
my
one.
most interesting case. And it was most interesting to me because it was on the first 48. I won't say what city, because, you know, but yeah, it's on the first 48. In a big city, rough town, for sure, you know. But it was just so many factors that we looked at, and the police report was 2 pages long. I was expecting, you know, somewhat of a little book. No. And everything that we needed to see was redacted, you know, about the other witnesses and the other person that was shot. It's redacted.
And that's what a couple other questions. If the ADB was paid before an investigation is complete, then it turns out it shouldn't have
Then
been any recourse.
only recourse is to try and sue the beneficiary to get your money back. File suit.
You have to ask.
You have to file suit. Yeah.
And then you have to go to court.
Mm-hmm.
So better to wait.
Most insurance companies aren't going to go to court. I mean, this particular policy was the legal fees, just consulting legal fees would have been eaten up before you did that. You know, if you have $1 million accidental death benefit policy, yeah, you may want to, you know, recoup your
Go to
money.
court.
Yeah.
And then can you pay the base when the question regarding the beneficiary's involvement?
You can pay. Well, no, you shouldn't pay the base. This particular base was paid because they said we couldn't rule the mother out.
But you didn't want to do the extra. You know what I mean? Yeah.
You don't want to do the extra. We had no opinion on the base. We can only opine on the accidental death benefits. So.
Gotcha. And so if they, on the fall, if you see somebody, you said you were going to tell us something about, like, if there was a witness to an actual fall.
Yeah. Okay. So I had a case, this was many years ago. I had a case, a man was playing bingo in the bingo hall in his church. He had history of stroke, cardiovascular disease, and syncope, those three. Okay. He was playing bingo, gathered his stuff up, stood up, fell, and hit his head on the concrete floor in the basement of the facility, wherever he was playing bingo. I believe it was a church. But I'm not positive, so don't quote me on that. But he hit his head on the concrete floor as he was trying to take his first step. Now that's a witness fall. All of the witnesses had the same thing. He was fine, he was talking, he stood up, he fell and hit his head. He has a history of syncope. He didn't pass out. He has a history of stroke. Didn't have a stroke, has a history of cardiovascular and cardiac artery disease. Could that cause somebody to fall? Absolutely. A change of blood pressure can cause you to fall, get dizzy and fall, right? They didn't say he wobbled or anything. He literally stood up, fell down and hit his head. They did an autopsy, no aneurysm, difficult to see if there was a heart attack before, when you're looking at somebody who had an autopsy, no stroke. Syncope, he didn't faint. Was he dizzy? We don't know. Any of those diseases can cause dizziness. Any of those diseases, you know, just like I said, the change in blood pressure from positional change of blood pressure can cause someone to fall. So that was a hotly debated claim in the claims department.
And what was our decision?
And what was our decision?
And the end of the story?
Yeah, what would our glorious audience do with that one? Okay. I think we're pretty much there. Okay. I'm going to go ahead and end this poll because I think we're about right where we need to be. And share the results. 79% say it's payable. 21% say it's not payable. Jill?
I'm thinking payable because you couldn't prove it was the syncope. Nobody looked at him and said, hey, it's, you know, he was woosy or whatever, is acting weird.
Absolutely correct.
Didn't grab his chest and say, oh, Elizabeth.
Probably. He didn't do the Fred Sanford on us and fall out. Yeah, none of that. So we recommended to pay. The seating company paid. And this was a witness fall. And probably, yes, one of his conditions probably did cause him to fall. You know, probably won't stand up in court though. Okay, so this is what I wanted to bring, these funny cases that have all this background information and we end up paying. The ones that we don't pay are fairly straightforward. You know, you get a car accident, the person has a blood alcohol content of 0.13 something or whatever it is, pretty cut and dry. You were drunk, you know, you can't drive drunk. What else? Oh, you know, person has heroin, cocaine, marijuana in a state where it's not legal to drive under the influence of marijuana, you know, or to not legal to even, you know, smoke marijuana, states such as Texas, you know, they're under the influence, they get in a car accident, whether that's their fault or not, they should have not been on the road, the claim is not payable.
So because the last one, he really wasn't doing any driving or anything like that, even though he had a little bit of marijuana in him.
It's not illegal to walk with marijuana.
No, I thought you said he had a little bit of marijuana in his system.
He did, and it's not illegal to be at a party with marijuana in your system. Be at a party in possession of marijuana in your pockets, very much so. My thought on that claim was, I think someone stole the drugs from him.
Could be. It's
And
like,
that's
well,
why he got shot.
crime of convenience. Everybody's running. Oh, hey,
Everybody's running and you run, and you know, or if he was
carrying it, yeah.
having a transaction go on and somebody snatched it from his hand, you know, and he knew he was going to get shot, took off and ran, and they shot him in his back. He was in the commission of a felony when he got shot. None of that is in the report, though.
But nobody would fess up to it.
Right. And I'm sure with 20 or 30 people out there, somebody knew what happened.
Especially if it's not by the street, it's in a house, between houses.
Between two houses.
See, that's, I don't know if I can be a claims person, because I can, as an underwriter, I can decline that. Nope.
So when you start claims, and to all my claim folks out there listening, please understand we are stuck on that contract. We are stuck on those exclusions. And what can I prove? Take those two boxes that are going at it in your head, set the one that says payable down in the deposition seat, and set the one that says not payable down in the deposition seat, and put the most, I don't know famous lawyers' names, but put that defense lawyer in front of them. I don't know who's a famous defense lawyer besides.
Well, I know Shapiro from
Shapiro, that's what I was thinking, Shapiro. Put Shapiro in front of them. You know, God rest his soul.
And I don't think, I guess Robert Kardashian is famous. I don't think he did much for that one, but he was there.
You know, put them in front of them.
There you go.
If it doesn't fit,
somebody was like, if it probably wouldn't stand up in court, shouldn't the other case be paid, since the mother can't be held accountable? But you can't prove it either way if the mother was the one that killed him.
And then the thing about that one is they paid the mother on the life benefit.
They just didn't want to pay the extra in case she was involved.
But you've already paid her. So she's already profited if she was involved.
Yeah.
Probably not. The mother was known to be sitting on a porch or chair when the melee started. She didn't run, but doesn't mean she didn't have anything to do with it.
Correct. Yeah. Well, these were very cool, Michelle. Thank you very much for sharing this. Is there any
everyone's
questions?
Tolerance with my technical difficulties here. I kind of like to do things like this, more of a chat. Now I'm rethinking my thing, but I will definitely get these case studies copied and pasted over for you so that you can take them and use them. What I would love for everyone to come away from this particular webinar with is to think and rethink and really set yourself down in that deposition chair, you know, and don't just let the biggest boxer win, because it's a David and Goliath situation. With insurance companies, we have to think about where we are, what state we're in, what laws apply, what exclusions, and what do those exclusions say? Because the young lady who had drugs in her system, if it said that she was driving under, you know, that you're not allowed to drive under the influence of prescription drugs, you know, or narcotic prescription drugs, you know, exclusion is that detailed, we would have had a non-payable claim. You know, so really take a look at what your exclusions say, read it, rip them apart, you know, and if they are vague or ambiguous, just like on any other contract language, tie goes to the runner. And it is, that language is on the side of the insured. Yeah, we have no wiggle room on claims. You guys have a little bit of wiggle room in underwriting. We have none on claims.
Yeah, I mean, you can always ask for more stuff and hope it goes away because you have your doubts, and you can, it's like, okay, well, you know, I think we need another APS, or we need to ask the client more questions because you know there's something that's going fishy and you can't prove it.
Correct. And I'm sorry, this is the results of the last poll. Correct. You can ask for more, but you also too have to be careful about phishing, like we do with our contestable claims. We don't want the appearance that we are trying our best not to pay the claim. We want to just try our best to make the best decision on the claim. You know,
I mean, eventually you have to give it up. I mean, it's like, I can't prove it. I can't prove it. There's nothing for me to do. But you're just hoping that the person gets tired. Like if you have a traveler or something, they might get tired of you asking questions and like, okay, we'll go to the next insurance company.
Yeah.
But
and you know, even myself, if I were to put myself in the beneficiary shoes, if I was a mother who, you know, like I said, this policy wasn't very big. Maybe she has outstanding bills that she needs to pay for, you know, and I'm not getting something that this policy said that I should be eligible for, and you have no proof that I shouldn't get it.
I'd be calling you every month in the beginning and then every other day now.
Yeah.
So, yeah, no, I get it. I get it. Well, thank you very much, everyone. Is there any more I don't see any other questions. Like I said, if you guys want, it's in the chat, the info us@optimumre.com.
I will get this stuff copied over because I can do it on my other desktop and it won't be a problem. I will get this stuff copied over and load it up for you guys sometime this week, pretty soon here. So I thank you guys for your patience and time with me with this presentation. And thank you, Jill, for always being my good Vanna White.
All right. I like it. I any day, Michelle.
All
Have
right.
a good day, guys. Bye.
Thanks, guys. Bye-bye.